dozens of law review articles at journals across the country.
All right.
Professor Salib is also a former federal clerk, a contributor of many law review articles, and a figure at UH. All right, well, thank you. Please see the sign sheet if you have it.
Can I reserve some Chick-fil-A before we start?
Yes.
You're out
You're
of Chick-fil-A.
out.
Oh my God.
You know what? You snooze, you lose. So a good part of being a law student is being on time for deadlines. So it's always good to know. I'm sorry. We'll take your Chick-fil-A a bit later, okay?
I accept.
I accept. All right, but you know what? I got water for you. Want some water?
That's lovely. Thank you.
So you know what? We share. All right. Well, thank you so much. It's great to be here. I teach at South Texas, which is on the other side of 45. So this is very easy for me to get to. The topic today is a Supreme Court term that just was. And I always like to begin with some statistics, some numbers. Last year was a very big year for the Supreme Court. We had the Dobbs case, overruled Roe against Wade. We had Kennedy, overruled the so-called Lemon test. We had Bruin, which held the Second Amendment applies outside the home. This was by any stretch the most conservative term in the court in any of our lifetimes, maybe in the last several generations. How did this term fare to that term? Well, the court still leaned to the right, but perhaps not so strongly. And in fact, many of the more high-profile decisions have broader public support than you might think. So, for example, the affirmative action decision. 52% of Americans support that decision. There's a case about a website designer who didn't want to make a website for same-sex marriage, what Peter was talking about. That one split 43% approve, 42% disapprove. There's a student loan case, which you might all not like very much, but that was approved by 45% of the public. So as a whole, this was not a right-wing landslide. Let's go a little bit deeper with the numbers. Last term, 14 of the 60 opinions had a 6-3 right-left split. So 14 of 60, which is a pretty high clip. This term is only 5 out of 58, so less. Last term, there were 10 5-4 decisions where all the 3 liberal justices stick together. This term, there were 6 5-4s, in 4 of which the liberal bloc stuck together. That's fewer ideological splits than we've seen in many years. Okay. Moreover, half the decisions this term were unanimous, which is about normal. And at least one liberal was in the majority in 89% of the cases. All 3 of the court's liberals were in the majority in nearly 2/3 of the divided cases. Okay. Let's go a little bit deeper. If I were to ask you, who's in the majority more? Justice Clarence Thomas or Justice Ketanji Brown Jackson? What would you say? Of course, Clarence Thomas, right? No. Justice Thomas was in the majority about 75% of the time. Justice Jackson was in the 80s. So we actually have it that the most conservative member of the court, Justice Thomas, is also in the majority the least. Not what we expected, is it? The other story of the past couple of years has been Justice Kavanaugh and Chief Justice Roberts. They are 2 peas in a pod. They vote together at 95, 96% of the time. It's very rare either of them are in dissent. And Justice Kennedy, I'm sorry, see what I said. Justice Kavanaugh is the new Justice Kennedy. Indeed, he's the court's fulcrum. He's the majority over 95% of the time. He almost never, ever dissents because he doesn't have to. Because usually he's either the 5th or the 6th vote in any sort of divided case. Third in line is Justice Barrett. She's in the majority 91% of the time. So between Kavanaugh, Roberts, and Barrett, that is the center of the court. Now, while Justice Kennedy was often the center of the court for about a decade or so, here we have 3 justices who form the center. So in any given case, the left needs to pick off 2 of the 3, and they do so on a more expected basis than one might have thought going into it. Justice Alito and Justice Thomas vote together the most, and they are in the high 70s, low 80s, depending how you count. So this is not the right-wing court, or as I like to say, the Supreme Court is not the Fifth Circuit. If anyone, if President Trump had picked any of the Fifth Circuit judges for the Supreme Court, we'd have a very different country right now. But he didn't. So as they say in the movie, you're welcome. All right.
Did they ask you first? Is that the you're welcome?
No. They didn't pick our good friends from the arrest courthouse down the street. I want to talk about a couple cases, as will Peter. The first case I want to talk about involves election law. This was the biggest case in the world that turned out to be not very much at all. Moore against Harper. All right, what's this case about? The Constitution says, and I'll just read you the text, the manner of holding elections for senators and representatives is prescribed, blah, 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 by the legislature thereof. Right, so the Constitution says that the legislature thereof, that is the legislature of the state, can make the rules governing the election for senators and representatives. Okay, now it says legislature. It doesn't say state courts, it doesn't say state executive branch, it says state legislature. What does that actually mean? During the Bush v. Gore litigation almost 20-something years ago, Chief Justice Rehnquist had a concurrence. And he said, well, you know what? The Florida Supreme Court, you guys did way too much, right? The reason why is the Constitution says the state legislature makes these rules, and the state Supreme Court, the Florida Supreme Court, actually the acronym is Supreme Court of Florida, the scofflaw, right? Scofflaw could not make rules governing recounts, okay? Why does that matter? That concurrence sort of gave birth to a theory known as the Independent State Legislature Doctrine, ISL, Independent State Legislature Doctrine. The thinking going that the state legislature has a constitutionally assigned role in deciding election rules. But we all know that in the last decade or so, state courts have gotten very engaged. They've intervened with regard to redistricting, on regards of political gerrymanders. They've intervened on COVID voting protocols. The state courts have a lot to say about the elections for federal office. And so this North Carolina case arose, right? The North Carolina Constitution says all elections should be free. And on the basis of that, they made challenges, they accepted challenges to redistricting based on the political gerrymandering doctrine. The state legislature appealed, and they said that the state courts stepped out of line. They could not make these rules. Now, in the lead up to this case, it was described as the biggest nuclear bomb potential ever. That if the court ruled in favor of the North Carolina legislature, it would give Republican states the power to override the voters and just hand the next election to Donald Trump. The hyperbole in this case was quite high. What actually happened, I don't think any of the justices actually accepted that strong version of the ISL. Maybe Thomas Alito, though I don't think I'd go quite that far. Instead, the court ruled by a 6-3 vote in favor of, well, effectively, the North Carolina Supreme Court. It's sort of messy because the court changed composition, they reversed, but the bottom line is the decision, the court was upheld by a 6-3 vote. And the court basically said, well, legislature doesn't mean legislature, but if you go too far, we'll stop you, right? Chief Justice Roberts does what he does best. He has this very broad ruling saying, well, you're allowed to do it unless you go too far. So I think for the most part, the fear is that the Supreme Court would green light the overthrowing of democratic process proved a bit too much. The court didn't even go that far. Still, the Chief Justice said there might be some cases where the legislature does too much, the court does too much, we'll stop them. And Justice Kavanaugh made a similar point in his concurrence. The dissenting, which was by Justices Alito, by Thomas, and Gorsuch, said the case was moot. I mentioned this before. While the case was pending, an election was held. And the composition of the state court flipped from a Democratic appointed majority to a Republican majority. And they basically said, we are going to overrule the prior decision, but left the judgment in place. I think the case was moot. There was nothing to decide, but at a minimum, this issue is now resolved. So I think the state's legislatures can't go rogue in the 2024 election, although I think they were going to do that anyway, but who knows? All right. That's the first case I want to talk about. The second case involves religious freedom, religious liberty, called Groff versus DeJoy, Groff, Groff versus DeJoy. Who is Gerald Groff? He was a Christian who did not want to work on Sundays. So he took a job that actually fits his schedule very well. He became a postal employee. As you probably know, the post office didn't deliver mail on Sundays. That all changed because of Amazon. Yes, you guys love your packages showing up on Sunday. The Postal Service now delivers packages on Amazon. And that created a problem for Mr. Groff. He would not work on Sundays. So he actually tried to work around it. He kept transferring to smaller and smaller offices so he wouldn't have to deliver packages on Sunday. But eventually, Amazon took over the world, as they do, and all postal workers had to work on Sunday. So I think, wait a minute, Josh, why can't they just accommodate Mr. Groff by having someone else pick up his shift? Well, that works, I suppose. But even in a very small office, people don't want to work Sundays. That's a non-desirable job. And the way it would usually work is it would rotate, where you would work one Sunday a month and he'd work one Sunday a month and so on. So you get the full schedule covered. You might have to pay overtime or extra wages to get people to work on Sundays. But he refused. So he brought a lawsuit challenging the Postal Service's denial of his right to not work on Sunday. There was a problem with this case, though. The law certainly says that you can't burden religion, but there was a precedent from the 70s called TWA versus Hardison. That's Trans World Airlines. For those of you who don't know, TWA versus Hardison, a very old case. And what that case says, if a religious accommodation poses even a de minimis burden on free exercise, you don't have to accommodate the burden, right? So if there's even some small de minimis burden on your employer, you can just say, sorry, you have to work on Sunday, too bad. This was a case that's basically half a century old. It goes to the Supreme Court. What does the Supreme Court do? Unanimous 9-0 victory for Mr. Groff. Now, you don't get a 9-0 victory at the Supreme Court very often, especially not in a religious case. But I think this case was actually pretty easy. The statute itself says that you must accommodate unless it creates an undue hardship. That's language use, an undue hardship. An undue hardship is not the same thing as de minimis cost, right? De minimis is very little. Undue hardship is, that's a big deal. Now, if you're Walmart and you employ millions of workers, is really going to create a hardship to give a guy a different shift? Of course not. If you're the Postal Service, is it really going to create a hardship? Fine, maybe pay overtime wages or something else, but this is not going to be an undue hardship. But the court didn't overrule Hardison. This is where the Roberts Court sort of does this magic. They say, well, it turns out that you've actually been misinterpreting Hardison for the last half century. Surprise, right? It's been there in plain black and white, and you've all been reading it wrong. We don't overrule the precedent. I mean, come on, this is nuts, right? They overruled Hardison in all but name only. But as a result, going forward, there's going to be a duty now to accommodate religious objections, even if it imposes some hardship, some difficulty, some cost on the employer. For example, if you have to pay overtime wages and so on, you're going to pay overtime wages, right? We're talking maybe a few $1,000s a month to cover overtime wages. That is good enough. One of the questions that arises, though, involves organized labor. What if you have a labor agreement with seniority rights, where usually it works is if you're lower on the pecking order, you get the bad shifts, and if you're more senior, you have seniority, you get the better shifts. And the court seems to say, well, we're not talking about that. You can't override labor arrangements. So at least if you have a union agreement, you're not giving the lousy Sunday shifts to the senior person. I think at least that's probably the rules it stands for now. All right, let's go on. Let me do Mallory. Are you covering Mallory in CivPro?
Yeah, I will. Not yet.
Okay,
Yes.
I'll talk about Mallory for a minute. Right?
Mallory's great.
I love this case. Okay, so have you all taken CivPro or taking it now? If I say personal jurisdiction, do you go into cold sweats and PTSD? Okay, so right, there are two types of jurisdiction, broadly speaking. There's the personal jurisdiction and subject matter jurisdiction. Right, subject matter is diversity or a federal question or so on. But in order to get to federal court, you must also have personal jurisdiction. Did you all study international shoe? Minimum context?
Everyone who took my class.
Say yes, nod and smile.
Yeah.
Minimum context, yes. Stream of commerce, right? Remember all these topics?
They even know about tag jurisdiction.
Oh, and tag. Oh, I love tag jurisdiction. The guy in the airplane ride going into the jurisdiction, right? But generally, to get to federal court, you must have some context. So that could be your place of incorporation, or maybe your principal place of business, and so on. But you gotta have to have some contact to a jurisdiction before you're hauled into court. Pennsylvania had a funny law. Pennsylvania law that said if you do business in our state, you must consent to personal jurisdiction. You have no choice. So you have a railroad, right? Norfolk Southern. Norfolk Southern has tracks all throughout the United States, and they have tracks through tracks in Pennsylvania. And they have a right to do business there, so they must consent to jurisdiction. A tort happened. I'm going to simplify the facts, make it easy. The tort happened in Virginia. The plaintiff lived in Virginia. The corporation incorporated in Virginia. So again, it's a triple Virginia case. The tort happened in Virginia. plaintiff, citizen of Virginia, corporation, incorporated in Virginia. I'm simplifying facts a little bit. Where did they bring the lawsuit? Philadelphia. Why did they bring in Philadelphia? It was probably a judgment that the trial courts there were more favorable to the plaintiffs, and we can make judgments on that, but that's the decision they made. So Norfolk Southern moved to dismiss for lack of personal jurisdiction. That there's no connection between Pennsylvania and the tort. There's no connection between Pennsylvania and the defendant, and there's no connection between Pennsylvania and the plaintiff, right? This is just a unconnected form. The plaintiff said, but you consented to do business in Pennsylvania. You are subject to the personal jurisdiction of Pennsylvania courts. All right. This case goes to the Supreme Court. What does the court hold? Okay. Who here thinks the court's conservatives ruled that you can't bring this case in Philadelphia? Okay. Who here thinks the court's liberals held that you can bring in Pennsylvania? All right. Let me just give you the vote here. The majority: Gorsuch, Thomas, Alito, Sotomayor, Jackson. More time. Gorsuch, Thomas, Alito, Sotomayor, Jackson. You will never see that split ever again for as long as you're alive. Who's in dissent? Barrett, Roberts, Kagan, and Kavanaugh. So this is the we love procedure case, right? If you love CIFPRO, you were in the dissent. And if you hate CIFPRO, you were in the majority. The issue was, is international shoe the rule, or perhaps are there other rules? And maybe Peter will correct me as a good CIFPRO professor, but the majority seemed to say that international shoe was not the only game in town. That you could that you needed to have something. I'm sorry, that the 14th Amendment put really no limits on the Pennsylvania statute. In other words, Pennsylvania could impose this requirement. Even in the absence of so-called minimum contacts, the Due Process Clause still allowed jurisdiction. So the court ruled in favor of Mr. Mallory that he could bring his tort lawsuit in Pennsylvania. Either the tort happened in Virginia. The court split a little bit because Alito was like, well, there's some old precedent, we'll stand by it. Alito thought also there might be a dormant Commerce Clause violation. The idea that Pennsylvania is burdening commerce in other states. So this case isn't over, but Mallory pulled out a victory by the skin of his teeth. Justice Barrett, who again taught CIFPRO, like my good friend Peter, dissented, and she said, "This is in conflict with international shoe. How dare you call into question half a century of CIFPRO jurisprudence?" But Gorsuch got a majority just by the skin of his teeth, and this is sort of a strange case. All right, one more case, actually two cases, and I'll turn it over to Peter. Student loans. So I won't ask, but how many of you have student loans? I think every hand will go up. Yeah. So wouldn't it be nice if the government just said, just kidding, never mind, you don't have to pay? Wouldn't that be nice? Not so much. During the pandemic, the Trump administration, Secretary DeVos said, we are not going to collect interest on student loans. We're not going to impose penalties and so on. What gave DeVos the power to impose those rules? The HEROES Act, HEROES. The HEROES Act was passed after 9/11 and broadly stated, it gives the secretary power to waive or modify statutes. Waive or modify statutes concerning student loans during a national emergency. So DeVos claimed that COVID was a national emergency, which it was, and therefore they can suspend the collection of debt. Okay. The administration changes from Trump to Biden. And Biden said, okay, now hold my beer. They said, not only are we going to put the payments on hold, we're going to cancel billions and billions of dollars of debt, right? And there were formulas about who was eligible and so on, but they canceled a lot of debt using the same statute that says you can waive or modify. Now, it's known that Congress considered bills to cancel student debt, and those bills did not pass through. So the executive does what he often does. He turns to old statutes to find ways to accomplish, to deal with modern day problems. Okay. The challenge here wasn't necessarily the merits, that is, was the policy lawful? The challenge is what's often called federal court standing, right? You can't just go to court and complain because you don't like something. You have to be injured by it. Who is actually injured here, right? Again, the policy remove debt. So maybe yesterday you have to pay a bill of $1,000. Now your bill's zero. Are you injured by the elimination of debt? No, it's actually the opposite of an injury. It's removing a burden, right? If they make you pay something, that's an injury. That's easier, right? But here they're removing the obligation to pay. So opponents of this policy had to get creative with standing, and there were two approaches. One was a guy named Brown who lives in Texas. The case was actually called Brown versus Department of Education. Irony is not dead. And Mr. Brown, Mr. Brown argued, wait a minute, I'm not eligible for this money, right? You guys exempted my type of loan, so I'm not eligible. I want to be eligible. So what remedy do you seek? To strike down the entire policy. In other words, you're talking common law, you level up or level down, right? He went to level down. He says, well, because I'm not eligible, no one should get it. That actually worked in the district court, as most things do in Texas, I suppose. It worked in the Fifth Circuit also. He's smiling. I got him to smile.
As most things do in this Fifth Circuit.
As most things do in the Fifth Circuit. But the Supreme Court 9-0 unanimous rejected it, saying this was an Alito opinion that was only a few pages long. It was very short. And Alito said, yeah, that doesn't work. You're not injured by the government's decision not to pay you money. Therefore, that case ended. Another case, though, did make it across the finish line. And this is a case from Missouri. There's an entity called MOHELA. MOHELA, MOHELA, funny acronym, stands for the Missouri Higher Education Loan Authority. And most states have these sort of entities that process student loans. And as I'm sure you know this, when a student loan is issued, there are fees, right? You pay an origination fee and so on. You've seen these all in your statements if you read them, unless you crumple them into the garbage, like I used to, perhaps, right? MOHELA, in theory, would have earned some fees from processing and servicing these loans. Now, to be candid, they wanted these loans wiped out because it's a lot easier to get free money from the government than to have to go chase down a bunch of recent college students, right? That's a fact of life. But it's true that this organization would have some fees that they would not get. If MOHELA had challenged the student loan cancellation policy, I think even the Biden administration would say, okay, they have standing. They might lose the merits, but they have an injury. But MOHELA did not bring the suit in their own name. Instead, the Missouri Attorney General brought the suit on behalf of MOHELA. And let me tell you, MOHELA was really quiet during this process. They did not say a word. They didn't say, we agree, we disagree. They were just silent because they didn't want this, right? They wanted the policy to go forward and wipe out all the debt, and it would make their lives easier. So the actual case turned on whether this sort of quasi-state entity was part of the state, such that the AG could bring the suit. And we had a John Roberts opinion, and the Chief Justice does what he always does. He finds something, didn't really matter what. And he found some state precedent saying that MOHELA was something like a quasi organ or entity of the state, and that was good enough. So as a result, the court said MOHELA has standing, and the AG can bring suit on behalf of MOHELA. I have no idea if that's right or not. I don't know Missouri law, but the court seems to think so. Now we get to the merits. The court said that this phrase, waiver modify, cannot be used so broadly to reach wiping out billions and billions of dollars of student debt. All right? The language is not that broad. And the court invoked, I don't want to trigger anyone, the so-called major questions doctrine. Have you heard of this? This was a thing when I was in law school. It's become very, very prominent in recent years. The idea is when Congress wants to do something very big, major, right, they must speak clearly. They must have a clear statement of congressional authority. To use Justice Scalia's famous imagery, Congress does not hide elephants in mouse holes, right? When they want to do something very big, they're going to say so. Indeed, Congress has considered canceling student loans. They haven't actually done it. Then the court said this is a bridge too far. The statute doesn't support it. You had a concurrence by Justice Barrett, who says, well, you know, this major question doctrine is not that big of a deal. It's just sort of a contextual canon. It's just sort of reading statutes in context. I'm not sure if she's right, but at least Justice Barrett is starting to think about it. Justice Kagan has been on a warpath against the major question doctrine for a couple of years now. She hates it and said this is the opposite of textualism, right? How are you calling yourself a textualist? And you look at what Congress did not do. In other words, Congress did something. Let's read the text, but you're basing your decision on what Congress did not do. But Kagan is in the minority there, and I think we'll see more major question doctrines pop up and up and up. All right, those are my cases. I think Peter has a few he wants to talk about. Thank you so much for your attention.
Thank you, Josh. Yeah, so Josh has, I'm looking at his screen here, extensive notes on the cases he's talking about. I guess I'll apologize in advance. I told Michael I'd do this as long as I didn't have to prepare anything because I didn't have any time. So I'll just speak off the cuff a little bit more than Josh did about a couple cases that I think are interesting. I don't know, maybe some thoughts about some of the stuff that Josh said. I guess I'll just start by saying, I'm not really invested in it either way, but I'm not sure the kinds of summary statistics about the polling on different cases or like Clarence Thomas's dissent rate show whether this was I think I could just agree that it was not as big a case for conservatives as the prior term. Dobbs was a very big decision, sort of a culmination of one of the major goals of the conservative legal movement. So, credit where credit's due. That was a big victory. But, when I think of partisan stuff generally in the United States, I think that about half of people support those things and about half of people oppose it, whether those things are things the Supreme Court does or things that a state legislature does or things that a president does. And so a lot of these this polling suggesting that, SFFA, the affirmative action case, was supported by about half of Americans is just about what I would expect if it was a favored position of one party or the other. So I'm not sure which way that cuts or how strongly it cuts either way. Clarence Thomas, I expect to start writing more and more dissents because the majorities don't need him anymore. So he's the weirdest justice, I think. I think he has the most idiosyncratic jurisprudence. And it used to be the case that there were only 5 conservatives on the court, 4.5 if you count Anthony Kennedy as half. And so you really needed Thomas in your majority. And so you really needed to write the opinions in a way that got his vote, not just for the result, for both the result and the opinion. And, in a 6-3 court, the majorities don't need to court him as much, and he doesn't need to have them court him as much. So he's much happier to write separately and endorse the weird views he has, whether that's in a concurrence or dissent. And so, in equilibrium, I think we should just expect lots of separate opinions from Thomas going forward. What's my sense of the term overall? I think there were some important victories for people on the right. And I guess if I have a theme coming away from this term is the victories are piling up in such a way that it's becoming a problem for you. For one, if one is part of the conservative legal movement. And so what do I mean by that? Why could victories become a problem? It's in some ways for the reason I think Josh highlighted right at the end of his presentation when he brought up the major questions doctrine. One thing that's interesting about originalism and textualism is that while I think there's an argument that maybe originalism in particular on balance is a conservative leaning doctrine on average because it literally conserves rules from many hundreds of years ago. And if you think that public views have changed on things those changes are correlated with partisan preferences, that originalism will on average favor conservatives. But as Justice Kagan points out in her Mohila dissent, not uniformly, right? You get some rules out of textualism and conservatism textualism and originalism that favor conservatives and some that favor progressives. And if it turns out that you simply have the votes to vote your policy preference, if you're conservative, you might be tempted to be less textualist and less originalist. And the major questions doctrine is, I think, if you were being cynical about what the court is doing, a way to do that, right? It turns, I mean, maybe, as Barrett says, it's an ordinary rule of statutory interpretation that we like read things to do read statutes to do kind of like normal everyday stuff instead of big stuff. But if that's true, as Josh points out, we've had we've had the elephants and mouse holes rule since I don't know how old.
Mid-90s, yeah.
The mid-90s, and haven't paid a lot of attention to it. And so insofar as I think Justice Gorsuch and maybe others have a renewed interest in the major questions doctrine, you might worry that it's a way to inject judicial preferences into decisions more strongly than if you hewed to the text in a more literal way. So maybe it's one thing that's going on. You have votes to vote your or you have the votes to implement your preferred policies, but your preferred or your professed preferred judicial philosophy doesn't always get you there. So you rely on rules that are squishier, that give judges more discretion. You might worry about that. Maybe that's a big sort of meta move by the conservatives on the court to be a little less originalist and a little less textualist than maybe they said they were for a long time. And I think let me preface by saying, like, I'm not a pure legal realist. Like, I actually think law matters in some cases. I actually think that that's what's going on in the personal jurisdiction case. Actually, one thing we learned in my personal jurisdiction class is that unlike subject matter jurisdiction, it's waivable. It's waivable in a lot of ways. You can show up in court and litigate. You can write a forum selection clause that waives the right to object to personal jurisdiction. And now it turns out that also you can waive it by doing business in a state where they've written a law that says if you do business here, you can be sued here. And a round of applause for formalism, right? I think that that's a weird split, in part because it's like there's like a pretty compelling case about the law, right, as opposed to about the politics. And so I think law does some work. But I guess since Josh mostly talked about politics, I'll take a sort of political view on some other things that I think are happening as well. So here's one thing that happened. In Students for Fair Admissions versus Harvard and its companion case against the University of North Carolina, I guess I'll say something that isn't true and then tell you why I think it's mostly true. The Supreme Court overruled Bakke, Grutter, and Gratz. Now, Josh is nodding because he agrees that that's not literally true.
I agree in both.
Yeah. So the Supreme Court declined actually to say that it's unconstitutional to take diversity and to take, on the basis of promoting diversity, to take race into account when doing college admissions. They said, yeah, in theory, you can still do that. Diversity is a rationale to do race-based affirmative action. And then they said, but here are a bunch of things you can't do when you design your specific policy. And I think all those things you can't do are all the things you would have to do to have any viable policy that actually ever made decisions to promote diversity that involved consideration of race. So I think the court, we'll say, effectively overruled Grutter and Gratz and also Bakke, which are the cases that said you can do race-based affirmative actions to promote diversity in college admissions. I have an essay that's coming out soon in the Texas Law Review arguing that this seems like a big deal, but in fact won't be a big deal.
So with Guha?
Yeah, with Guha. Have you seen the draft?
I saw it.
And the reason that we argue that it won't be a big deal is that colleges will simply lie about.
He will not sit under oath, though. He will.
I'm not involved in admissions at any university. I'm not speaking on behalf of any university. But as the essay argues, since at least Grutter and Gratz, the things that the court has said about what you are allowed to do when considering race in admissions are so hard to comply with that there's no way to actually practice affirmative action and tell everybody how you made decisions without violating the rules of Grutter and Gratz. And that's been known now for 20 years-ish. Those are cases from, I think, 2003. Is that right? You always know the year of the cases.
2003.
So when you actually look at the discovery in the SFFA case, Harvard and USC say on their websites, here are the things we consider when we do admissions, your SAT scores, your grades, your extracurriculars, also diversity, race to promote diversity. If you actually look at how they make the decisions, they never write down that any applicant's race mattered in deciding whether to admit that applicant. Like never, zero. And that's what they've been doing for 20 years since Grutter and Gratz, because Grutter and Gratz said things like, you can consider race, but it can never be decisive. Like, what does that even mean, right? It can be a factor, but it can never tip the scales, right? Like in what sense is that even a way in which you can consider race when making the decision if it never decides, even when the two applicants are otherwise in equipoise? So look, colleges will do what they've been doing for 20 years, which is decide however they want to admit whoever they want, and they will simply never write down the reasons they admitted any particular applicant. And so here's me actually circling back around to my point about the conservatives being a victim of their own success. We argue in this essay that this will be like actually a pretty successful way to evade the ruling if you want. Now you might say, well, what about all the statistics, right? SFFA had all these statistics about like different SAT scores for different racial groups and what got you in. And like if you were Asian American, your average SAT score for getting to Harvard had to be much higher, and on and on and on. And the answer is none of that stuff is very relevant in trying to litigate an equal protection case. Since the 1970s, a case called Washington versus Davis, the Supreme Court has held that to prove a violation, a constitutional discrimination claim, a violation of the Equal Protection Clause, as opposed to like Title VII statutory discrimination claims, to prove a constitutional claim for discrimination, you can't do what's called a disparate impact approach of proof. You can't show different statistical outcomes and thereby make a prima facie showing of discrimination. What you have to do is show intent. You have to go like, I don't know, like depose the in this case, admissions officer, or in those cases, the police officer, and say, why did you admit this person? Why did you brutalize this person? And if they say anything other than because of their race, well, you don't have a claim. Now you might ask, well, the majority on the Supreme Court has as many votes as they like. They could just vote to overrule Washington versus Davis, right? If they really don't like race-based affirmative action in college admissions, they could say, Washington versus Davis is no longer good law. You can bring a disparate impact claim to prove a constitutional violation. The problem is that rule would be like quite cross-cutting politically, right? On the one hand, it would let people who didn't get admitted to colleges bring a lot more claims. On the other hand, it would let people who were like brutalized by the police bring a lot more claims, right? And so like if you were deciding what to write in your opinions just on the basis of your political preferences, which again, I'm not saying the Supreme Court is, but if you were, you might not know what to write down. Like what's the rule now for bringing a claim based on, an affirmative action policy or an alleged secret affirmative action policy that a college might continue to have? The court could continue to say you need to show intent, and then basically no one can bring a claim because colleges know how to lie. Or you could say you can do disparate impact, and then like everyone can bring a claim, but all these other places where liberals have been saying since the 1970s that there's racial discrimination, those are good claims now too. So it's hard to write the rule that gets you the political result you want. Where else might this be going on? Maybe 303 Creative is a kind of example of this. So 303 Creative is the, I think you think of it as the follow-on litigation to Masterpiece Cake Shop. No Masterpiece Cake Shop, that's a case arising under a Colorado statute that makes it illegal for businesses that provide services to the public to discriminate on the basis of a bunch of things, including sexual orientation. Masterpiece Cake Shop basically didn't decide whether a First Amendment claim or a First Amendment challenge to that law was valid. 303 Creative is just the case where the Supreme Court now decides. The plaintiff here, I guess this is a declaratory, like a pre-enforcement declaratory action. I think we call that person the plaintiff. Somebody who owns a business, a woman who makes websites for weddings, who actually I guess doesn't make websites for weddings yet, but who wants to be in the business of making websites for weddings. We can come back to the standing question if you want to later. Wants to be in the business of making websites for weddings. Says, I am a devout Christian. I believe that marriage is only between a man and a woman, and I'm worried that if I put up my wedding business in Colorado and then refuse to make websites for gay and lesbian couples who want to get married, that the state of Colorado will come sue me. I guess the state of Colorado says, yes, we'll do it, right?
They did.
It's like a fake case in many respects. Like there's no website, there's no prosecution. And then there's other respect in which like maybe it's kind of a fake case. They stipulate to all the facts. They stipulate to a bunch of facts, including that making a website for a wedding is highly expressive conduct.
Yeah.
Okay. Supreme Court rules that this, indeed, this law is a violation of the First Amendment because it compels speech. This is weirdly a speech claim, not a religion claim. We can return to that weirdness also. I think this is another place where conservatives are maybe starting to become victims of their own success. It's hard to know what to write down post-Smith as to like what the content of a First Amendment free exercise claim is. Okay, so they say this is compelled speech, and that the Colorado law is unconstitutional insofar as it compels this speech. The speech effectively being like, gay weddings are fine or something. I made a website for it, so I must think it's fine. The state is forcing me to do that. The dissent has, I think, a very compelling argument that this rule like goes very far, right? That like it's hard to distinguish, for example, a photographer who might refuse to take photos of an interracial family on the basis of their objection to mixing of races, right? This would be like very, very classic discrimination within the bounds of a bunch of discrimination laws, including like federal ones, right? And so the dissent, I think, quite forcefully argues that the majority has, I don't know, in effect, overruled Title VII and a bunch of anti-discrimination laws, at least as they relate to a whole bunch of businesses, like not just website makers, but maybe people who have stationery shops and maybe people who take photos and on and on and on, depending on what you think is expressive. Cakes. Does Masterpiece hold that cakes are expressive? No, I guess not, right? They just say there's a discriminatory.
Religion.
Maybe cakes. The majority says, no, this case like doesn't do that because the parties stipulated that websites are quite expressive. And in some sense, that's like, I guess, a way of avoiding writing down a rule that seems far too sweeping. That would be, I think, quite unpopular, a rule that effectively holds that racial discrimination is fine as long as you're a photographer. But it's a weird thing for the Supreme Court to say, right? Like, if this is a case that applies to literally no other facts, including facts like the photographer case, which, you know, if making a website is expressive, surely photography is expressive. If the Supreme Court doesn't think the holding in 303 Creative applies to even that set of facts, the photography facts, like, why did it decide the case in the first place, right? That's the kind of thing that the Supreme Court normally, we call dig, dismiss as improvidently granted, say, look, this is not a good case for us to tell you about what the law means, so we're just not going to decide it. And so I find it quite puzzling that the court would write this opinion that purports to like explain the bounds of the First Amendment, but then at the end undercut it. It seems quite severely by saying, but of course this doesn't tell you anything about any other cases, including photographers. Maybe that's again because like it's hard to know what to write down, right? It's hard to know how to write a test that lets the website designer refuse to make a wedding site for a gay wedding, such that that rule doesn't also tell the photographers you can be racist if you like. Maybe that is the implication. Maybe we're finally seeing like, the free speech clause like subsume everything. But the court doesn't seem to want to say that yet, but it doesn't know what it would rather say instead. I think I was also going to say something about countermen, but I guess the only thing I'll say about countermen is it's also a speech case, but in some ways it's kind of a boring case. It's another example of like maybe law mattering. Countermen is a case that addresses the question, if you say something on the internet that seems threatening and you are sued in a state that allows you to be punished for threats, what is, you might think of as like the mens rea requirement to punish you? How much does the First Amendment say about what you have to have known or intended in order for the state to be able to punish you for that speech? And the Supreme Court says exactly what you'd expect them to say if you knew anything about First Amendment free expression law since the 1960s, which is the rule is basically the same for threats as for defamation, as for intentional infliction of emotional distress, which is you either have to have intended it to be threatening, or you have to have been reckless with your disregard of whether it might be threatening. So yeah, in a case like this with, I don't think much political valence, the Supreme Court continues to do like sensible and boring things that basically reflect established legal rules. I think that's all I have to say.
All right. We're a little short on time, so let's go to Q&A, and maybe I can work in some responses during the questions. So questions? Yes, sir. Right. The question we couldn't hear is, will the court get rid of Employment Division versus Smith? For those who have not taken con law yet, Smith was a Scalia decision from 1991. And it basically said, if the government burdens you for exercise, that's fine, so long as the law is neutral and generally applicable. That is, it's not targeting a particular religion. So to answer your question, I think the COVID cases, Roman Catholic Diocese, Tandon versus Newsom, and others, have largely weakened the bite of Smith. And what those cases said is, if the government treats some non-religion better than religion, that's unconstitutional. So, for example, if the casino stays open but the church stays closed during the pandemic, that's not enough, right? If a liquor store stays open but not a church, you can't do that either. That eliminates almost every instance where Smith might arise. I think it's going to be very hard to even find a Smith case or even grants, because almost anything would prevail under the COVID cases. But good question.
I would say I basically agree with that. I think the COVID cases effectively overrule Smith, but I would add that I think this is a place where we don't actually have like a coherent new rule yet. Mm-hmm. And in part because it's extremely hard to write a rule that doesn't seem to, I don't know, do a bunch of stuff this court might not want to do. So before Smith, we had Sherbert. Sherbert was a balancing test, like we find in many other parts of the Constitution, including the First Amendment. Actually, not so unlike intermediate or strict scrutiny. The idea was basically, if you want to burden religion, you can do it, but we have to ask how big a burden it is, what your alternatives are, what the point of the law is, whether it's a valid reason, and whether the valid reason and the results are kind of proportional to the burden you impose. This court doesn't like those kinds of balancing tests. Mm-hmm. They specifically said in the Second Amendment, we're not going to do them anymore. In some sense, I think that was actually the biggest deal in Bruin, more so than applying the Second Amendment outside the home. But the Roman Catholic Diocese cases actually don't tell us anything coherent about how to understand which accommodations of secular conduct are sufficient to require like a similar accommodation of religious conduct. So any law that imposes a burden on religion, like insofar as the law doesn't apply to everyone everywhere doing everything, like trivially excludes some secular conduct, right? Like, I don't know, a road safety law trivially excludes cycling, maybe, let's say, or trivially excludes hang gliding. Okay, that's a secular activity. Does that mean you have to have religious exemptions to road safety rules? I think the answer is no, but I don't think we know why under Roman Catholic diocese. In my view, the most sensible way would be to do something like what we did in Sherbert and what we do under the free expression clause of the First Amendment, which is to do some balancing, but this court seems quite allergic to that balancing. I don't know if it's because of sincere convictions that that's not what they did at the founding. If you were a cynic, you might say doing balancing is going to mean that they have to recognize like Satanists' claims sometimes, and they don't want to do it. And so that's the cynical explanation of the declension to write a comprehensive rule.
All right, maybe one more question. I think everyone knows class. I'm sorry. Thank you so much.
Yeah. Thank you.
Yes, sir.
everyone, for coming.
Good time.
Can
Good
I
to see you.
ask for
Nothing to
future,
say.
I hope to see you again. You didn't get a chance to sign in.
I,
When I see you, I was like, there's